Good morning, everyone. It's Susan Wartzman. We are just starting our webinar now. We've still got some people logging on, but it's 8 o'clock, so we're going to get started. Our topic today is information governance and how to manage information and some of the organizational risk associated with it. Today I have joining me Duncan Fraser from Wartzman's. I will let him introduce himself. In terms of when he starts his presentation, sorry, in terms of my background. For those of you who have been on and joined other webinars, you'll know that I am a lawyer at Wartzman's who practices primarily e-discovery. The firm has also been advising our clients for the last several years on information governance, both in terms of strategies, the laws surrounding it, and some of the more technical, practical aspects of how to develop an information governance strategy. So what I'm going to start with today is figure out how to get my slides to advance. Sorry, I'm just trying to get my slides to advance here, but they're not. Is just talking a little bit about the, first of all, why we need information governance, so we can get some, just so you have a baseline and a bit of an understanding as to why information governance is important, and really tying it into your legal practice and why it's important for lawyers. Okay, sorry, I now have my slides working. So the big reason I think the starting point is why is this so important is just to talk about the volume of data that we're going to be dealing with and experiencing in our world in general, but in our law practices as well. So first of all, I think one of the most staggering statistics that I've seen lately is that more data was created in the past 2 years than in the entire previous history of the human race. And that's going to only multiply. The projections are that will multiply over the next 5 years. Data is growing faster than before. By 2020, about 1.7 megabytes of new information will be created every second for every human being on the planet. By 2020, our accumulated digital universe will grow to about 44 trillion gigabytes. So those are big numbers. Within 5 years, there will be over 50 billion smart connected devices in the world, all developed to collect, analyze, and share data. So think about that in terms of information governance for your clients' organizations and managing that. And by 2020, more than 1/3 of the data produced will live or pass through the cloud. So why is this all so important? And starting with the business case for information governance. In response to the data explosion and all of those statistics that I was talking about a minute ago, organizations are going to absolutely need to introduce order and structure to their data. They will not be able to manage it otherwise. It's really coming to this understanding that organizations have. Their data is everywhere. It's in the cloud. It's on smart devices. Everybody's connected in multiple different locations. So how does a business bring order to that? And as a lawyer, it's important for us to have an understanding of that so we can actually talk to our clients about it and advise them about it. So on the business side, before we get to the legal case, on the business side, why do we want good information governance? Well, number one, an information governance strategy will allow for data-driven decision making. So what does that mean? For example, if your client is a retail company, they need data to determine the right price of the product, the right time to put it out to market, the right consumer. And if the organization has all of that data, then its decisions are based on its own information. But to get the data and to get all of it, and not just sort of the basic piecemeal, pieces of it, but to really be able to analyze the data, your client companies will need management and structure. Now, I think the second reason is information governance will actually allow organizations to innovate better. You're having a good handle and a good understanding of your information will give you a competitive edge. The most successful companies today are using their data and information to give them an advantage over their competitors. And it really gives this sort of added window or insight into the future, which guides business strategy. The third reason is for the business case is really saying, organizations generally tend to understand their business really well, and your clients, I'm sure, understand their businesses really well, but they don't always understand what data they have that they've collected very well. And we see this all the time when we're working with clients on information governance strategy, and we're talking to them about legacy data or active data, and they know that they have terabytes of data that they have collected, but they don't know what's in it. They know that they have 1,000 boxes of paper at Iron Mountain, or 5,000 or 100,000 boxes at Iron Mountain in storage, but they don't really know what's in those boxes. So a good information governance strategy will help them know where their data is stored, who should see it, when it should be disposed of, and it will improve the accessibility and the reliability of their business records. And then I guess the last point I'm going to make on the business case is, of course, the ROI of information governance and the return on investment. And this is really difficult to quantify, but certainly it's something that people are asking about all the time. What is the ROI? And really, the ROI, the obvious one is the reducing the cost of storage, both in terms of paper and electronic records. I know that even internally in our law firm, as we are moving to a new information governance strategy here, we're going to be reducing our storage costs by 50%, easily just by eliminating and taking offline information that we no longer need to have. So if you think about a company that's paying for storage for petabytes of data and information, and that a good strategy might be able to save them 50% of their storage costs, that's a significant ROI. In terms of the legal case, so when we talk about information governance with business people, so if we're talking to IT, we're talking to the CFO, whoever it is that we're talking about the business case. The legal case is different. As lawyers advising our clients on why they need a good information governance strategy, from a legal perspective, we need to talk to the clients about risk and compliance, both the risks of storing information that you shouldn't and the risk of non-compliance with legislation governing the retention or disposal of information. And I mean, the risks of storing information, clear, obvious one, a cyber breach. So companies who are storing information that they shouldn't have, and then they're subject to some kind of a security breach or a data breach, the cost of remediating that breach is multiplied based on the volume of data that is actually obtained during the breach. Another clear rationale on the legal side for information governance is litigation readiness and the ability to be able to better respond to litigation in a cost-effective and efficient way. If an organization can immediately understand the records and the information that may be relevant to litigation, it can probably have more productive early discussions with opposing parties, both about the discovery as well as potentially settling its case. A party can also best defend against unreasonable e-discovery production requests if they know their data and they can actually produce it to the other side, find the key documents and say, look, we'll give this to you quickly. A good information governance strategy will also help protect and avoid your client's information from inadvertent destruction, both in terms of spoliation and destroying evidence that may actually help your case. And finally, I think good information governance allows organizations to comply with privacy obligations and how they're dealing with their employees or their customers or their clients' personal information, and to be able to protect that. So, you've sort of got this, list of all of the potential risks. So, we're often asked by clients, why do we want to spend money on an information governance strategy, and why do we want to start looking at putting new systems in place and implementing change? And so it's really this multifaceted answer that we give them. One, of course, is there's a good business case to be made for both a return on investment, but making your business more competitive, more efficient, and on the legal side, protecting from all the legal risks. So I'm going to turn it over now to Duncan to talk a little bit about what the courts in Canada have said about information governance, why it's important, and then to sort of talk about what some of the recent case law.
Great, thanks, Susan. My name is Duncan Fraser. I joined Wharton just about a year ago after leaving the Department of Justice litigation branch, where I spent almost 20 years, eventually as director of their e-discovery litigation support group, and with collateral roles in information transformation and information governance. Thanks for watching our screen and listening to our voices. I believe you have the ability on the webinar to ask questions. Please feel free to ask questions. We'll, time permitting, we'll answer them during this webinar. If not, we'll get back to you afterwards. This, as Susan said, this is an IG session, but as a law firm and as lawyers in Canada, we look at information governance from the perspective of the law. A good place to start if you're, which slide, thanks. A good place to start if you're a Canadian e-discovery lawyer is with the Sedona Canada Principles Addressing E-Discovery. Revised in recently 2015, Principle 3 now has a commentary that specifically addresses the elements of information governance in the e-discovery space. The commentary reads that the possibility that a party will have to demonstrate that it used defensible methods in the handling of ESI and that it maintained proper chains of custody makes effective information governance practices all the more important. The integrity of electronic records begins with the integrity of the records management system in which they were created and maintained. IG has become an area of judicial commentary, and the reality is that these information practices that Sedona has noted directly relate to proof of issues of both liability and damage, and they're being considered by the courts almost like akin to a duty of care and obligation with respect to information. On the screen, we have a quote from Master and now Justice McLeod, a well-known proponent of proportionality, and he makes his view pretty clear. The issues of information governance in the e-discovery space is cost and proportionality. And if you were to ask him, you'd find out very quickly that you'd better get information governance or you're going to be in big trouble when you're being judged on your practices. We'll look at a couple of cases, I think about 5 or 6 that I'll go through very quickly. The first, one of the earlier ones, was a decision in BC relating to documents that had been destroyed early on in a piece of litigation, and in fact before the litigation was commenced. What the court said in a numbered company and Imperial Oil was that commercial prudence dictates the adoption of document retention policies that preserve the means of the investigation of claims. In other words, if you're in a business that is likely going to need these documents, then your business should take steps to preserve them, notwithstanding a limitation period in that case. Alvey and YM is a wrongful dismissal case, and in this case there was a specific provision for the retention of payroll records under the Employment Standards Act, and that period was shorter than the limitation period in the case. The court was clear to comment that failure to have a retention policy that requires the retention for a period beyond the limitation period and other statutory requirements risks the court drawing an adverse inference. The Crown isn't immune to this type of sanction from the court. In Savoy, which was a tax reassessment case, the tax Justice Hirschfield was dealing with a reassessment that took place 7 years after the tax year, was dealing with the CRA, who has a policy to destroy tax returns after 5 years, meaning there was a destruction 2 years before the taxpayer was told of the reassessment. In that case, the court was not sympathetic to the Crown and was concerned the documents that would be helpful to the taxpayer had been destroyed. Obviously, that was unacceptable. I won't deal with go over Farid and Wood and Toronto Police Services Board in any detail. These are both adverse inference comments on the failure to have documents available because of the destruction of those documents pursuant to policy or lack thereof. The important case on this slide is the Siemens decision. This is an important decision if we're looking at the retention or destruction of information litigation, particularly in Ontario. Master Short, following on Warman, dealing with a matter in which the email policy of one of the parties was to empty the mailbox every 30 days or have the mailbox emptied on a rolling 30-day basis, and required the employees to move documents into a document management system if they were important. This was a big concern. One party had disclosed lots of email, the other had disclosed very few because of this policy, and Master Short says in that decision, obviously a company is entitled to establish whatever email retention policies it wishes. However, in a project such as this, which obviously carries on over a lengthy period of time, such a policy can create serious problems. And here's the caution for us as lawyers. Given that there is a 2-year limitation period for most causes of action in Ontario, counsel will perhaps need to consider advising their clients on the risks of such a policy and the appropriate manner of dealing with such deleted emails in the event of future disputes. The message from these decisions is pretty clear. You should have clear retention policies. They should be followed. They need to be reasonable. And if you're involved in high-risk activities, you need to ensure that you keep the documents for a period at least as long as the limitation period. I have, Susan jumped to the last one. One warning for keeping information. The courts aren't sympathetic to people over collecting and over preserving personal or protected information, in part because there's always a risk of a breach. And if you're breached and you have information unnecessarily, you're likely to find yourself in more trouble with the courts.
And in addition to the trouble that you may be in with the courts, and of course your customers, you're going to have the cost increases incrementally by the volume of data that's subject to the breach. So now I'm going to go back and sort of talk about how do we actually get started on this, and how do we design and implement an information governance strategy. And that's the real challenge, is where do we start? And what we like to talk to clients about is, developing a holistic strategy. So it's very difficult now. I think the days are gone when our clients call up and say, can you help us with our records management policy? And 5-10 years ago, we used to hear that all the time, and it was easy. It was one policy, and you could take a look at that policy, and you could update it, and you could revise it. But that doesn't really work anymore, because you can't really have a records management policy or an information management policy. Even if you want to call it an information governance policy, it doesn't really matter. You can't have that policy in isolation from the tools that the organization is going to use, and in isolation from other policies that are related to it. And because information is so volatile and it's so easy for it to be moved around, you really need to develop a strategy that has that covers, that integrates all of the organization's information. So starting point is, first thing you have to do is know your client really well, and you have to know its own culture. One of the largest, most significant challenges in putting an information governance strategy in place is trying to get employees, like you can develop this whole strategy, but if you implement it and then walk away, and none of the employees follow the policies and the procedures and use the tools and technology, the project will be a failure. So for the project to succeed, what you want to do is make sure that you understand the culture so that you will be able to know what works. So number one, we start with interviewing employees. We've got to learn the landscape. We have to know what tools are they currently using, where are they storing their information, how are they storing their information, why do they need their information. So you have to get a good handle on that. So we'll often interview and talk to multiple different employees at different levels, senior executives, very junior people, people who are really managing records, people from IT. So we want to get a cross-section of people to interview. The next step that we'll review all of the existing policies and procedures. So the existing policies and procedures, which will, that list of a records management policy, legal hold policy, email usage policy. Most organizations now have BYOB policies as well. So we want to review all of those existing policies and try to merge them into sort of a more compact package for the organization and an overall strategy. The next thing that we'll do is identify the technology needs, which are quite specific, and I'll talk about that a bit later, but the list of requirements that would be on that list. And finally, we want to align people at the organization. We want to make sure that we have organizational buy-in, so we want to determine who's going to own the project, who we're going to work with at the organization. So armed with all of that information, what we can then do is prepare a report for your client, which is really a gap assessment. And that report includes the findings and observations and analysis based on the employee interviews, a list of key recommendations, an outline of the legal and regulatory framework that applies to your client. So if it's a financial services institution, for example, there's going to be some specific regulations applying to it. And the report should also include a data map, which is really talking about where the employees store their information, and summarizes of all the standards and policies. And that report, it becomes really clear when your client sees that report what they need to do. They'll see very clearly what are the results of the employee interviews, what comes to the top. Are all the employees complaining about how their emails are archived and stored and how difficult it is to access them? Are all of the employees complaining about access to their information when they're traveling, when they're outside of the organization? And those kinds of standard problems. Are they complaining about security protocols that are in place? How can that be fixed? How can that be modified to allow them to do their jobs better? So those are generally that report informs the next stages of the process. So the deliverables that you're going to give to the client, so that sort of leads in. So first of all, I just talked about the State of the Union update and that report. And that's, the first thing that you're going to talk to your, have for your clients to see. The next thing that I think in terms of deliverables that you want to talk to your client about and deliver to them is a new information governance. And it says in the slide policies and procedures, but what you really want to start off with is the policy, which is a motherhood statement. This is what the organization's goals are. This is how the organization wants to manage their information. Preparing the procedures is really a different step. It's drafting the day-to-day. It's the standards or the procedures that the employees are going to use day-to-day, and they're going to need that as well. The other deliverables that every organization is going to need is they're going to need a legal hold policy, a classification plan as to how they're going to classify their records, email instant messaging usage protocols, and a BYOB policy usually. The classification plan and then a retention schedule obviously as well, which sets up the retention period. The classification plans that clients historically have in place have hundreds, if not thousands, of different types of ways to classify records. And we're really trying to move away from that now in terms of classification plans and simplify them. So if you listen to people speak about information governance and classification plans recently, you'll probably hear people talk about the very eloquent big bucket approach is what they call it. But what we're trying to do with the classification plans is reduce the number of record classes down to 100 or less and put them into a very plain English, simple terms so that not only employees know how to classify their records, but actually if you want to put in place auto-classification systems, it will be much more manageable. And we started off 10 years ago. I went into a client and looked at a classification plan that an employee had prepared. I think he spent years on it. I think he spent a day trying to walk us through it, and it would have taken me months to understand it, and it probably took him years to prepare it. Something like that's never going to be workable. So we've had to really, accept and try to move away from that into a very, very simplified approach to a classification plan. And I think, in talking about, dealing with clients in terms of an information governance strategy, I think that what you need to be saying to your clients is, we're going to give you this report. It's going to have a lot of recommendations, and then in that report, you're going to say, and boom, here's what's coming next. You're going to get all these policies and procedures, all of these particular documents, and then we're going to move into the technical solutions and how we advise them, which is, I'm going to turn it over to Duncan in one moment to talk about the technical solutions, but there is a question that's come in, which is, are there any ways to make it easier for employees to work within a new policy in cases where there was no prior existing policy and they were retaining everything? I think the answer to that is that the ways to make it easier for employees are, number one, don't try to change too much in their world or they will rebel. But understand their world, and then, of course, you can make it easier for them. So if there was no prior existing policy and they were retaining everything, likely their real problem is finding information because they have too much. So the solution for them, and to make it easier for them, will be to create a system where they can actually access their information, and there's a structure to it, there's sense to it, and it's easier for them to find it. So on that note, I'm going to turn it over to Duncan to talk about developing some of the technical solutions.
Right. Everybody likes to hear a lawyer talk about developing technical solutions, and we approach it a bit differently here. First of all, let's make one thing completely clear. Information governance is not technology. It is enabled by technology, but if you treat these as purely technology projects, you're almost certain to fail. Let's take a look at how you would approach one of these projects if you are dealing with technical solutions. First of all, it's really, really important to define your objective and set achievable goals. And in answer in part to the question, if a policy is imposed on staff and it's not achieving a goal that the employees have participated in or accept as valuable, then they'll tend to find a way around it. So what are the objectives that you can look at if you're dealing with information governance? It could be managing email. It could be reducing duplicates. It could be preventing redundant or outdated or trivial information from being on your system. It could be developing a knowledge management system or just enabling defensible disposition. You need to come up with a list of things that you're trying to achieve as part of this project. Then my strong recommendation is that you establish principles upon which the technical solution will be developed. Things like the digital record will be the official record, that you'll have an open by default policy so that access privileges to documents will be not restricted unnecessarily. These things are hard to maintain and implement anyway. That you'll have one authoritative copy. Another is that you won't burden the users with a huge amount of work in order to have governed information. Best practices are that employees really should have about 3 decisions to make when they're classifying documents, and I personally think that 2 is plenty. And as I said earlier, stakeholders have to be involved in this. Once you've decided what you want to achieve and the parameters around how you will achieve it, then you can look at I recommend you look at what's out there in the marketplace, what is available, and arrange for presentations. You need to be informed in these projects. This industry has moved very quickly, and there's an awful lot out there that can satisfy business needs. Once you have an understanding of what's out there and you know what you want to achieve, Susan mentioned it earlier, you have to have detailed business requirements. Don't focus on the technical. Look at what the business needs. How does the business use information? Where does the information go? Who needs access? Why do they need access? How do they do their jobs? And build those into your requirements.
So some of the things that, Duncan, that we've talked to clients about in terms of listing sort of their functional requirements, I mean, the things, just to give you an example, like concrete examples, they want to know about email management. On this list of requirements, you're going to need something that responds to their email management needs, records management, archiving, how they're going to collaborate with amongst themselves, document management, the ability for search and retrieval, the hosting model, whatever multi-language needs they have, support ability needs, security and control, disaster recovery, workflow, how they're going to report, backup and restore. So there's this whole long list of the technical requirements. So when you're going to look for a tool, which is what Duncan's talking about, you need to know, actually have that list in front of you so that you can find a tool or multiple tools that will respond to that and meet those needs.
Right. Once you've got your list, you're going to then it's a matter of selection, and selection needs to be, you need to engage people who will be using the system in the selection. They need to see what they're getting, they need to participate, they need to decide what's a priority and what isn't a priority, and run a proof of concept. Most organizations, most suppliers will provide that. Don't treat that as the final product. Treat it as a true test environment. Find things that you want to change, engage your staff in looking at things that would make it easier for them to do their work, and move from that proof of concept into a final iteration. Continue to work with change management, with your staff, and with training. Training is really important. A policy dropped on people without training and support will not be followed.
When you're talking about engaged stakeholders, you're talking about typically for the technical solutions, you're talking about IT.
I'm talking about both. I'm talking about the staff needs to
no, but actually picking the technical.
Picking the technical is going to be done with primarily led by a technical team, but it has to meet the needs of the organization, which includes the staff.
So one key piece in this world of information governance is disposing of records. And I'm just going to talk about that for a couple of minutes because I think it's where lawyers really need to come into play in how they're advising their clients. So generally, we are not seeing the types of clients that Duncan talks about in the case law where they're retaining email for 30 days. We're generally seeing the opposite. We're seeing the hoarders who keep everything forever. And we're more concerned with how to end that practice of hoarders keeping everything forever. And that's where we like to come into play, and we think, well, we can actually advise our clients on, as lawyers, on what is legally defensible disposition. I think it's a lot of the reason that we started looking at information governance so many years ago, because we had clients coming to us and saying, we've got this policy, it's been developed by a records manager, it's been developed by somebody in the company, but we need a legal opinion. We need somebody to tell us that the policy is legally defensible, but that it's correct that we can dispose of the records, some of our records. So then a note on the slide is cleaning up rot. So rot is, so what do you actually want to be able to dispose of? You want to dispose of rot, which is redundant, obsolete, and trivial information. And our clients and most organizations are storing vast amounts of rot. In email alone, what we're seeing when we're doing some data scans and analyzing our clients' information is that sometimes more than 50% of the email, and sometimes up to 70 or 80% of the email stored by our clients is redundant. It's just multiple copies of the same email. And they also printed off paper copies, and there's a few of those stored too, just to add to the mix and the joy of having, 25 copies of every single record. Transient records, obsolete records, trivial records, all of these records, that's the key, is to get that disposed of immediately. And, I think our clients really need to be able to have an opinion where somebody's looked at retention periods. Back to the case law. Have you looked at the retention periods? If you know how long you have to keep it, you know the limitation period, so, you've got all of those risks. And then dispose of the rest of it. Because what we're, clients are saying are keeping everything forever. So we're not talking about a 5-year or 7-year period that we're fussing over. But we have clients that are keeping information that's 10 years, 15, 20 years old, and it's accumulating. And so that's the problem with the legacy data. In terms of the active, and that's obvious, at a certain point in time, you have no more business needs, there's no legal hold in place, there's past this, it's the life cycle of usage for the record, it's time to dispose of that record. In terms of active data, we're also finding that organizations are just keeping too much active. And that's because they aren't able to organize and sort out what is the transient information that they really don't need to keep for very long, like when are we going to meet for lunch. We've got a question that's come in. What are your recommendations for saving emails? Do you save all or just the last one? What if there is a branch off the original email? So in terms of saving emails, and Duncan, you may want to weigh in on this as well, you don't need multiple copies of the same email. And what technology can allow us to do is allow us to remove what we call redundant or non-inclusive emails. So if you can remove the redundant emails, so it's a chain and I send it to Duncan and Lauren in my office, and Duncan hits reply all, there's no attachments, it's clear his is the final, and my email does not need to be saved. So that one's easy. If there's branches off the original email, that needs to be saved because it's not the same record, and the technology will clearly identify those, and it will also clearly identify which emails have different attachments, and those aren't considered redundant emails. And so there are tools, and we use them for e-discovery. There are tools that do email threading that allow you to really segregate those. So the only thing that you really want to say is if you want to save emails for whatever, let's say it's a 3-year period, you want to find that email, you need one version of it, and anything that's absolutely identical to that, which you can determine by the MD5 hash value of that particular email, anything that's identical to it, that can be disposed of.
We could do an hour on email and email management. The shortest answer is email is can be a business record like any other record and has to be treated as such for compliance, for privacy, for litigation holds. The problem with email is there's so much more of it, so many discrete pieces. And as Susan said, if it's not necessary, it doesn't need to be kept. But separating the wheat from the chaff is either a technology tool with duplicates and with threads, or it's a human decision. Both have advantages and disadvantages, and they probably both play some part in the system.
What's really interesting is that when we're talking to clients about information governance strategies and developing strategies, they sort of want to know, where do we start? And there's a whole list, right? Do you want to start with your legacy data and clean up? Do you want to start with your active data? And one of the things that we advise clients is start with something that's easy. Don't start with email, because email is not one of the easiest pieces in there. Start with, for example, maybe paper and clean up the paper, or start with your file shares, because your file shares are simpler. But there's no question, email's complicated. So now we're sort of going to talk about, this actually segues really well into our next topic, which is the different challenges with different types of data.
Thanks, Susan. I'll go fairly quickly through this because I'm assuming that anybody who's worked in the discovery space has some familiarity with these terms and what they mean. But I'll do a little bit of definition first. I'll deal with legacy and active data. Legacy data is really enterprise information, so it's information that's owned by the organization that's difficult to access or use due to its age, organization, or its format. It's generally static. It's not being used. It's heterogeneous, and it's of unknown value in terms of the content. This legacy data generally represents some form of risk for an organization. It's the risk of deleting it and what might be the risk of not deleting it and what might be kept unnecessarily. That tension often leads to these repositories or these containers being ignored. Active data should be exactly the opposite, dynamic, relied upon for current business transactions, and adds value to the organization. If you're talking about the goal in information governance, it would be to increase the value of this active data and give all of it a purpose and direction until it can be disposed of or stored properly. When we talk about active data, it's what most of us are putting on our shared drives in our email systems and document management systems daily. This active data has the highest risk for people. It's active and it's used in the organization, and it also has the highest reward value for if it's managed properly, because it supports current business needs. There are good reasons to treat these two differently. One is the risk and reward equation, depending on the organization where the priorities are. Remember I said earlier, you have to decide what your objective is. If your objective is to deal with a growing pile of legacy data, it's a really good place to start. You can clean up the outdated, the trivial, the obsolete content without too much complexity and save money in terms of storage and reduce the risk of a breach of that content. It's also a good place to start if you're trying to demonstrate value and demonstrate the efficacy of these systems. If you're looking at a very active organization with an increasing problem in managing active content, then although there's a high risk in attacking this first, there's a high potential reward in terms of business enablement. Structured and unstructured data, this is one that most of us will be familiar with from the discovery space. Structured data has a high degree of organization. It's typically database type content. It's searchable. You can build algorithms that can organize it, manipulate it, and again, unstructured data is essentially the opposite. When I'm explaining unstructured and structured database to people, and I'll go with the email context here, your address book in Outlook is structured. Everything's got a field. You've got a name, you've got an email address, you've got a postal code, you've got a country, all in the address list. Your email itself is not structured because the content, what is in there, isn't categorized in any way. There's no attribute to it. Structured data, we generally think structured databases are information governed. That is not necessarily so. And when you're looking at dealing with clients on these, take into account that there may be no information lifecycle for any content in a structured data, and it has to be managed as well. It can't just keep growing forever. The unstructured data is probably what most people are dealing with when they're dealing with information governance at the outset. It's often more than 80% of your organization's content. Unstructured data is generally thought of as ungoverned data, and that doesn't need to be so. There are lots of ways to govern unstructured data. We asked, should we treat them differently? Absolutely. They are completely different beasts, and if you're engaged in information governance on structured databases, you'll need somebody with good familiarity with the structured content. With active data, I'll go right back to what Susan and I were saying earlier. This deals with active organizational information, and you'll need to involve both the business side and the technical side in dealing with governing that information.
So how does what's the collision really between information governance and litigation readiness? And maybe collision is the wrong word, but the intersection between them. And I talked about why good information governance earlier, why good information governance will support litigation readiness. But now what I want to talk about is the intersections, and that's really the tools that have been developed and the technology. So the tools that were developed largely to support technology-assisted review, in essence, analyze the content of a document so that we can predictively code the document or whatever it is. And for those of you who joined that session, you'll know about predictive coding and TAR. So the tools that allow us to analyze the document in that way, which so software can look at the content of the text in a record and it will predict whether the record is relevant or not relevant, privileged or not relevant, privileged. Similarly, that technology can be used to classify records, and that's what I was talking about, auto-classification. And auto-classification is really significant in the new information governance strategies that we're developing, because what we've learned historically is that employees do not want to have to classify their records. They can't be bothered, they don't have the time, and the systems are too complex. And what's brilliant now is when we can implement systems that will do that for us automatically. So that the system will actually say, yes, this is a banking record, or yes, this is a loan agreement, or whatever the document is. And so taking that and removing that piece of the process away from employees and having it done to some extent automatically is a real advantage to clients to enable them to understand their information better. So how do you get to that point where you can actually train a computer or machine to be able to classify your records? There's really two ways of doing it. One, you can put the system in place, which is your document management system, and you can have the employees start by classifying their records, and then as they input information, that will train the machine, and it will then start to automatically, when it has enough information, be able to have enough information that it can classify the records going forward. You could also have a records manager work with them and do that. An alternative way of doing it is setting it up ahead so that you actually have your business units provide you with examples of documents. So they would say, here's 50 loan agreements, and you call them all loan agreements, you load them into the system, it trains the computer, so when the next loan agreement comes along, it will auto-classify that document as a loan agreement, and then you can have the employee say, yes, I agree, that is a loan agreement, or no, I don't. But it's this ability to actually train the computer as to what the type of the communication is, what the type of record is, and it will auto-classify it. That removes that entire human aspect of it. So you're probably saying to yourself, how is that even possible that they could get it right all the time? And of course the answer is there's no chance that technology is at that advanced yet. And so one of the things that you're going to have to tell your clients when you're advising them about this is really, you know, we're not going to get 100%, and the auto classification is going to be nowhere near 100% accurate. But even if it's 70% accurate, that's a huge step in having, you know, 70% of your records actually properly classified so that you know what they are and you can identify them and they're properly stored, and then you can access that information. So, you know, trying to sort of jump to, well, this doesn't make sense, it can't work, it's all about really reasonableness. The same as e-discovery. These tools are never going to do the perfect job, and they're never going to be able to identify and classify every single record. But if they can get us a lot of the way there, you know, more than halfway there, we're way ahead of where we are now, where we just have these masses of information that are unclassified and unknown to the organization in terms of their management of their data. So I'm just going to turn it over now to Duncan, and we're going to talk, or he's going to start to, and we're both going to talk to you a bit about the emerging technology for information governance and for e-discovery.
Try and cover in 6 minutes or less emerging technology for IG and e-discovery. There's an awful lot of technology out there, and the industry is moving very quickly. Keep in mind, though, that most of the technology that's being developed right now doesn't care at all about information governance. It's social, it's entertainment, it's convenient. There are some that are directed at IG directly, but I want to deal with the the others as well. So I've organized it by good, bad, and ugly. I'll start with ugly. The ugly right now, social media apps, things, the social side of things, tweets, Snapchat, Instagram, Facebook. There's often, for this type of content, there's often not one item or document that captures a conversation, and the conversation isn't owned by a single entity. It's often shared among multiple parties who are creating the content or the theme. This means that the content can be modified, it can be deleted, all without your consent or participation. There are tools dealing with governing or collecting this type of content, but most of them sit outside the IG space. They have been more e-discovery investigative tools, and they create independent data sets. Two others that are particularly problematic because of the size and their ability to index and find content is audio and video. Video is increasing at an alarming rate. Facebook has recently reported that they're expecting in 5 years that they will be have moved away entirely from text-based conversations if the pace of the move to video keeps up. Think about the volume of video that is being created, and now think of it replacing all of the text context.
And it's not just the volume of the video either, it's the size of those video files are absolutely massive compared to text-based files as well. Yeah.
And they're already edited when people put them up. So doing authenticity and integrity with a video that's already chopped up and edited can get quite complicated if you're dealing with from an evidentiary perspective. The Internet of Things is something that is terrifying when it comes to information governance. Discrete pieces of data that when combined have huge value, but it's mass information, inconsistent structure, no common ownership, and the entire value of the Internet of Things data is in the aggregation of everything in the collection forever. All data is good data is the philosophy. There are lots of risks in this space from a privacy perspective, and we'll have to wait and see where we go in terms of governance. In terms of the bad, I'm not sure it's all bad. The cloud, I'm up in the air on this. I actually didn't mean that as a fun, but this is the way of the future. Cloud services are focusing on unstructured data right now. Microsoft with 365, Google Drive, Apple, iCloud. This is where we can conveniently store stuff cheaply and forever. This has made the clouds almost like mini digital landfills. If we put it in the cloud, it's there and it's secure and accessible. The problem is that organization of this content is not included, and it costs a lot to develop it. Most of these, or some anyway, provide a capacity for IG. Office 365 is a good example. Full information management capacity, metadata management, retention, disposition, policy capacity, and e-discovery, but you have to build it. So if you're looking at a move to one of these services, look at the governance of the content moving into the cloud. Before you get in there, it will make it a lot easier. If we move into things, the good, there's a lot of good in the technology space, in part because of e-discovery and in part because of information governance. And Susan mentioned that sort of there's a synergy there in the types of tools. We did TAR last week, the technology-assisted review, and if you saw that, you'll appreciate the benefit of machine learning on the identification of content. When we talk about IG software, what we're talking about is, in fact, classification and organization, the ability of a computer to add metadata tags or attributes that allow us to group and retrieve documents. The basic metadata that comes with our content is generally inadequate for information governance. This is the date, the file name, the location, the file size. What we need is content classification, topic, purpose, the organizations involved, individuals involved, and the concepts included. Those are much harder to create, but they do provide meaningful retrieval capacity. IBM has done some digging into how well humans do in that tagging type space as opposed to machines. It's sort of interesting results. Humans are accurate about 46% of the time, cost 17 cents per document to have them categorize them, and they're less than 50% consistent. Computers run 60 to 90% accuracy, less than a penny per document is what they're seeing now, and of course they're 100% consistent. It shows that although computers aren't perfect, they are an awful lot better than humans, and so the the content classification using this technology is becoming being more readily adopted and becoming an important part of information governance programs.
And apart from the 17 cents to have it done by humans as opposed to 1 cent to have it done by computers, you also have to think about the employee time and the employee value, which is not very good, of having employees classify their records. They should be doing other things like their job and letting technology, whenever it's available, classify their records.
Right. We get back to the classification side. Once documents have been classified, they still have to be made usable and useful for the organization. And in the information governance, information management space, we talk about moving this into a taxonomy. So some form of structure that allows for browsing and digging down for corporate content. These structured classified categories, subcategories have been around in information management space for a long time. There's a question as to whether this form will last forever, but currently it's still the norm. If there are two ways that documents can get into two things that we can do with a taxonomy. Either you have a human draft them based on how the organization is structured and how people are looking for and retrieving information, and then you build a rule that takes your categories, so the classifications of the documents you've made, and says if it has these attributes, then it is in this subcategory. That is sort of a mapping type classification and taxonomy. This is the most common right now, where you build a rule, you test the rule, and then move content in based on the attributes. The next evolution of information governance is auto taxonomy. So the ability for the software to take a look at your content, and based on what your organization has created and what it's doing with information, will create a taxonomy for you that shows you effectively how your information should be organized for retrieval and use in the organization. This is much more like an artificial intelligence application, where there's less human intervention, and you just add the retention periods to each of the classifications. This is an emerging area, but it's one that has the potential to really speed up information governance, the taxonomy and classification aspect of information governance. This is a space that I'm watching with great interest. So I'll wrap up this element. IG, information governance, is important legally and from a business perspective, and it's getting a lot of attention in the software space, so it's an area where we can expect more automation to be able to make this more mainstream, more accessible to more organizations.
And the difficulty, I think, for us as lawyers is, you can't expect that we suddenly become the technology experts and that we can actually advise our clients on all the technologies. I think some lawyers can, most can't. But I think as counsel, what's really critical is that we understand the overall picture of information governance. We understand why it's so important to our clients, and we're really in a position where we're able to talk to them about risk and the risks associated, the legal risks, frankly, associated with having no information governance strategy or poor information governance strategy. And I think, what so many people are, or so many organizations are concerned about is it sounds like it's too big, and it sounds like it's too complicated to develop an information governance strategy. And so as lawyers, what the best response to dealing with that is, you don't need to deal with all of it. You take a look and you understand your universe, and then you try to deal with and implement the strategy in pieces. So deal with for example, your file shares first to clean that up. Then you're going to deal with your email. You're going to deal with your active data first. Then you're going to deal with your legacy data. So it's really, here's the plan. Here's what we're going to do, and it's not going to, in the next 6 months, this is going to be done. In the next, 12 months, this will be done. And so you really have to look at and think through what the overall plan is when you're advising your clients.
Yeah, there is no quick fix to an entire organizational information structure, but there are pieces that can provide real value in the short term, and you can build on quick success, on early successes to move an organization into a sort of fully governed mode.
So we've now just hit 9 o'clock. We had answered the questions that came in during the course of the session, so we're going to sign off. Thank you all very much for joining, and please feel free to reach out to either Duncan or to me with any additional questions that you have. Have a good day.